Good afternoon, everyone. We're glad to have you today. We're doing things a little differently today because Judge McBrayer has been ill, and he's being a real trooper and appearing here today via video because we don't want him close to us to give us anything. But we are here so that when we are glad that he is here to give us his wisdom. And are there any announcements? Seeing none, would you call the first case, please?
In re estate of John Jefferson Waller. Wherever you want to. I mean, if you're the appellee, you can sit there, appellate there, and you may begin when ready.
May it please the court, my name is Paulson Varghese. I believe probably listed on the docket is Mr. Rob Lieber. He left the firm, so I'm taking over the case from him, the appeal from him.
Oh, you were the lucky one.
Lucky recipient.
Drew the short stick.
Yes.
Okay.
Yes, and I represent the appellant Reverse Mortgage Funding. Before I begin, if I may, Your Honors, reserve 5 minutes for rebuttal. 5
minutes, of course.
Your Honors, the questions before the court today are two simple ones. Did the probate court err when it failed to award the full balance of the mortgage to appellant RMF? And did it err when it granted fees to an unsuccessful party at trial? The errors here are twofold. RMF should have received the full balance of the mortgage based on the language contained within the note and also the principles of equity. And second, the attorney's fees should not have been awarded to the unsuccessful party at trial based on Tennessee law. First, turning to the issue of whether or not the probate court erred when it failed to award the full balance of the mortgage, the facts of this case are simple, Your Honor. John Waller signed a deed of trust in a note. It was executed in September 2016 and then recorded in October 2016. The note specifically says that interest will be charged on the principal until the principal is paid in full.
Counsel, I want to talk about that amount a little. I'm struggling a bit with the math, and maybe you can help me. So, 2017, it's $51,700 approximately in cents, and now we're talking about $78,118. Now, crunching the numbers on 4.8% interest, I don't get to $78,000. It looks like there may have been an adjustment on the interest rate upwards during that time period from 2017 and between 2017 and 2022. Is that correct?
Yes, Your Honor. It was. I believe my understanding is there was an adjustment. Yes.
Is there any sort of notice that's provided to the estate as part of that adjustment in the interest rate? Or? Yes,
Your Honor. Based on the records in this case, that was provided in the note. And so the amounts aside, I believe that the number, even if we were to use the 4%, around 4% amount, the $51,773 would still fall far below what RMF should have received after proceeding to trial after 4 years. And the reason is that the note specifically, the language of the contract specifically shows the intention by RMF to collect interest until the balance was owed. The cardinal rule of contractual interpretation is that the court should attempt to ascertain and give effect to the attention of the parties. The Tennessee Supreme Court said that in Christenbury versus Tipton. Here, the reason that RMF obviously loaned the money is so that they would receive interest and make a profit off of the principal until the balance was paid. And here, the balance was unpaid until the trial court made its decision in 2020.
Counsel, is there any objection that's made by reverse mortgage between 2017, when the $51,700 gets set aside, and when the proceedings are finalized here, as to the inadequacy of that amount, or that the amount doesn't fully encapsulate the harm that's being done to reverse mortgage? Is there any type of filing that would have put the estate on notice, would have put the probate court on notice?
Your Honor, based on my understanding, there wasn't, but that may just be because it went to trial after 4 years, and so it appears that RMF probably thought that this issue would have been dealt with quickly, and sometimes, inequity and just the judicial processes are slow. And so I believe the intent of RMF was not just to collect the $51,000, the $51,773. It was to collect that amount at that point. That was the payoff amount stated, but it would have been whatever continued after that. And Your Honors, the payment of interest was a material part of the loan. There's no ambiguity as to the language contained in the note. The interest was to be paid in accordance with the terms set forth in the note. The payoff statement, coupled with the balance history provided to the probate court, was an easy means of determining this. The probate court erred in ignoring that language and ignoring and bringing in the outside email as justification for why it picked the amount of $51,773. To continue on, the probate court should not have denied RMF's interest based on the principles of equity. The purpose of interest is to fully compensate a plaintiff for the loss of the use of.
This is an alternative argument. In other words, you're saying this argument only comes up if we agree that the note didn't provide for interest. Is this an alternative? Okay.
Yes, Your Honor.
So before we leave your main point, I don't know that your argument has addressed the alternative basis for the judge's denial of interest and attorney's fees. In the order on the motion for turnover, the judge also said that reverse mortgage had failed to make a claim for payment. So was there a claim filed in this estate by reverse mortgage?
No, Your Honor.
What do you say about the statute that provides that all claims against the estate arising from a debt of the decedent are barred unless a claim is filed with the probate clerk?
Your Honor, could you restate the question, sir?
Sure. So by statute, it provides that all claims against an estate arising from a debt of a decedent are barred unless a claim is filed with the clerk of the probate court. And what I hear you saying is reverse mortgage made no claim with the clerk of the probate court. So why isn't that dispositive of this issue?
I believe, Your Honor, because of I believe RMF would have filed that claim But in March of 2017, the administrator in this case filed a motion to approve the contract and then filed a motion to delay the payoff of the mortgage. It was acknowledged that through those that the estate did owe the mortgage to RMF, and there was money to be paid to RMF. It was just that RMF was prevented from foreclosing on the property.
Well, but that's not, I mean, that in a decedent's estate, that's not an uncommon state of affairs that the estate, until it's wound up, you may not proceed with a foreclosure case. And I guess to the extent that your claim is secured by real estate, you're safe until the real estate is gone. But here there was an order allowing the sell the real estate, and it seems like to me this appeal misses the point that the judge has made about no claim being filed here. I mean, I don't know anything in the statute would excuse a filing of the claim here. I went back and looked at reverse mortgage's answers to the original petition here, and they didn't even file a counterclaim. So, I thought initially maybe the argument was, well, the counterclaim served as a substitute for filing an actual paper claim with the clerk of the probate court, but that apparently did not happen.
And yes, Your Honor. And so even, I guess, addressing that, that's where the argument of equity would, I believe, would be RMF's response, is that at equity, RMF was prevented from using these funds for 4 years, and so at equity, it would be logical and make sense for RMF to wish to receive the interest that it would have gotten if it had been able to receive the money earlier. To continue forward, Your Honors, the case of In Re Estate of Wallace states that attorney's fees are allowed if they are required, if the action is required and it benefits the estate. Here, the action was not required and it did not benefit the estate. Thank you.
Thank you. You'll get your rebuttal time. Ms. Burns?
Good afternoon. I'm Peggy Mathis. I'm the administrator of the estate of John Jefferson Waller, as well as attorney for the administrator, so it's pro se. I was involved in this trial a long time.
Have you, okay, so you're the administrator. Okay.
Yes, sir.
Okay, got it. I'm sorry I got you mixed up.
Oh, that's all right. The trial court did not abuse its discretion because it did apply the correct legal standard. It reached a logical conclusion and a reasonable decision based on the evidence. The court determined prejudgment interest based on particular circumstances of the case, whether the underlying obligation is disputed and the obligation is certain. The particular circumstances of the case is that RMF, well, start with the caregiver. The caregiver did everything to orchestrate Mr. Waller obtaining a reverse mortgage. She applied, she contacted them, she communicated with them, she set up all meetings, including the one at the end where he signs the documents. Mr. Waller, when he was verbal, stated, and this is what the court based his decision on. Mr. Waller stated that he did not want to die in a nursing home, he wanted to die at home. He didn't have the money for caregivers to stay at home. And every elderly person, including me, I don't want to die in a nursing home. But that was the circumstances of the case. Mr. Waller was a 96-year-old gentleman who was blind, illiterate, nonverbal, very ill. He had, I think, a sixth grade education. But anyway, everything, I guess he was informed and he understood that he could get some money from his place and be able to stay at home. That was what the evidence showed. When he signed the deed of trust in the note, and I think this was pointed out in Judge Kennedy's order, he was in a nursing home. He'd been there since August 15th. This was about September 7th of 2016. He was nonverbal, extremely ill. He couldn't say a word. A notary came that represented RMF, brought him the deed of trust, the note, voluminous documents to sign, which he signed with his ever-changing ex. And that's how this started. The note did say that the borrower promises to pay interest, but I did get a restraining order preventing RMF from foreclosing until the sale closed. When the sale was about to close, and the email correspondence is in the record, that I emailed the counsel for RMF and asked him what the payoff was. He responded and gave me the payoff amount. An order was entered allowing that payoff amount to be put in escrow pending the termination of the litigation to determine the rightful owner of those funds. The original complaint to recoup against RMF and also Annie Burns, the caregiver. So no case law was presented in the brief that states that the amount of the payoff in any case was put into escrow and then prejudgment interest was determined. This note was paid. It was paid in full in March of 2017.
So wait, you're saying that those funds were turned over? I thought the court held the funds.
The order stated that the funds could be held in the estate account, but in escrow. Nobody could touch them. The estate couldn't touch them. RMF couldn't.
Reverse mortgage wasn't paid then. You don't pay off a note until the note holder receives the payment.
Reverse mortgage, it was closed. The funds to pay off the note were put in escrow.
Okay, so and you're saying if I put funds in escrow for, say, my mortgage, I get the payoff for my mortgage, and I put them in an escrow account, the bank is going to say, well, I've been paid in full then.
An amount has to be determined to be what the payoff of that note is, and that was put in the order.
Okay, and what happened then?
Then we proceeded, unfortunately, with COVID, and it wasn't the fault of either party that this got delayed so much. But we went to trial. The complaint had asked for a rescission of the contract, which would mean that the funds would have gone to the estate.
But all that was unsuccessful. I mean, all your claims against reverse mortgage were dismissed, were they not?
They were, but not against the caregiver.
Okay, so just against Ms. Burns, was there a judgment of any sort?
Yes, Your Honor. There was a judgment for almost the approximate amount of what RMF put into the bank account because the caregiver took it all out. Mr. Waller never got benefit from the funds.
Yeah, so can it be any dispute here, can there, that reverse mortgage was denied the use of their funds that the court ultimately determined they were entitled to from the date of the closing and the date that the funds were put in escrow until today?
Well, they've been paid now, but they've received the funds. But yes.
Right. Yeah, so they were denied usage of those funds for some period of time.
But so was the estate.
Wait, why was the estate entitled to it? Because you were unsuccessful on your claim that reverse mortgage pays out the funds right into an account in the name of the decedent, did it not?
No, the funds were paid It's like an insurance company being an intervening petitioner. The funds are put in the court, they're put in escrow until it's determined who's the rightful owner. And if the estate had been successful, they would have been the rightful owner. Because
But the estate was unsuccessful.
the estate was unsuccessful against RMF, yes.
So, I mean, there's no question here that reverse mortgage was denied usage of their funds, I guess is the bottom line here. So I'm a little confused about how you can argue they were paid off when it's clear that the funds were held for some period of time.
Through no fault of anyone, they were held that long. I was obeying a court order, putting them in escrow. Nobody had access to those funds. And if RMF thought that they weren't paid, they had from March, I think 24, somewhere around the end of March of 2017, to September 24th of 2017, a year from the date of death of the decedent, to file a claim for any funds that they thought, and always a claim can be continuing. You know, as long as a claim can be filed saying, we're in litigation, this claim is good until it's determined. That was not done.
There was no claim here, and I think reverse mortgages conceded that. Reverse mortgage did not file a claim.
Correct.
And claims were required to this was an estate where claims were required to be filed. There was no reason. Okay.
Absolutely.
So why doesn't that resolve this issue? I mean, that was the alternative basis for the judges. So why do we have to go any further in our analysis here about entitlement to interest or attorney's fees? If they didn't file a claim, the statute says the claim is barred. Why doesn't that end the inquiry?
Well, that was my point, that no claim was filed, and the judge did rule that no claim was filed for any excess. And I think RMF knew that was the amount of the loan because their restraining order only went through the date of my sale of Mr. Waller's property. They never tried foreclosing on the new buyer. They never tried to enforce it. They knew that the buyer was...
Their deed of trust wasn't released as part of the sale?
I'm really not sure. The buyer was given a clear title.
The buyer was given what kind of title?
The buyer was given a clear title insurance.
Okay, so clear title would indicate that their deed of trust was released, so there would have been nothing to foreclose on.
And the interest was paid from the time Mr. Waller died and owed that money through March when it closed. They got interest on top of what they had given. There was just no valid deed of trust, no valid lien, no valid note anymore. So interest can accrue on a note that's been paid.
The note invalid.
Pardon me?
You said there was no valid note. Why was the note invalid?
Because it was paid in full. It was valid until it was paid in full. It was a debt of the decedent until it was paid in full.
Okay. So even though the full amount of interest due was not paid, you're saying it was paid in full?
Yes, that was the payoff amount to pay it in full that I was given by counsel for RMF. The estate, bringing up one point that Mr. Varghese was saying, the estate got no notice of any other balance due, ever, until the litigation, until the trial. And the invoices actually that I saw stated they were sent to Mr. Waller at his address in 2016. I was never sent notices of any other balance due. Yes, I know they make their money with interest, but there's also a lot of funds paid at the beginning when you sign up for a reverse mortgage. A little bit on the attorney's fees. The estate, I'm not sure why RMF can complain about attorney's fees for the estate counsel. He's not a claimant. He's not a beneficiary or heir. He has no standing because he's not, RMF is not affected by the attorney's fees. Once they get their judgment, their money back as ordered by the court, they really don't have any right to protest. But the estate was successful because they got judgments against the caregiver, the co-defendant, for the amount. And basically,
Counsel, did you argue your brief?
I don't think I did, Your Honor. It just
Okay.
kind of
So
came
should
to
we
me.
even consider that since you're just bringing it up in oral argument?
I'm just bringing up an oral argument, yes.
Okay.
But I still don't think they have standing. This case was the judge.
Counsel, were there adequate funds in the estate if reverse mortgage prevails? Are there adequate funds in the estate to pay the amount of the increased interest?
Um,
So with those attorney's fees
Probably-
being taken out of the amount?
Probably not.
Wouldn't that give
After
them a basis
admin
for
fees.
standing? After fees were removed, wouldn't that provide them?
Well,
with-
even court costs and admin fees prior to. It'd be really close.
Okay.
The way I saw it is Judge Kennedy, actually, it's kind of the equitable splitting of the baby. The estate got a judgment against Annie Burns, the caregiver, for taking all of Mr. Waller's money. For almost, it was right at the amount that RMF put in his account that she took with her power of attorney. And they got their money back.
So the attorney's fees are for the successful pursuit against the caregiver?
Yes.
Okay.
Or- Questions? Okay, thank you.
Seeing none, thank you.
Thank you.
Thank you, Your Honors. Just in regards to the argument about the 2017 email between counsel, the $51,773 amount, the RMF would, the appellant would like to point, Your Honors, to Ballou v. Gilmer. Although a statement of counsel in pleadings or stipulation or orally in court is generally regarded as conclusive judicial admission, an out-of-court statement is not usually attributable to the client, even in an informal evidentiary admission, unless authority from the client to make the statement is shown. Here, the record is absent as to the authority to RMF to make the statement contained in the email, and
As to the payoff amount?
yes, Your Honor, the payoff amount. The payoff amount was sent by counsel to opposing counsel in an email.
Would he make it up? I mean, he got it from the company, right?
Yes, Your Honor, he got it from the company at the time on March 21st, 2017. But the court shouldn't have relied on that in 2020 to make its decision with regards
Counsel,
to.
there's no additional claim filed for any increased amount, any continuing interest, no objection filed to that being an inappropriate amount. So, and reverse mortgage essentially sits for years, and then at the end says, oh, by the way, we owed all this interest. We didn't file a claim saying we owed this interest, and we didn't object to that amount. But you know, you can't hold us responsible for our response of our attorney in the email.
RMF did provide an affidavit during the trial to show the accumulation of interest, obviously after the fact, but it did show that interest accumulated to the balance that was shown of 78,108.
But there's no, let me just make sure I've got this right. There's no objection or claim that's filed between the time that 51,700 or so is set aside and the end of all of this litigation. RMF never comes in and says, that's the wrong amount. Actually, we're supposed to be getting interest also, and here's our claim for that, or you've miscalculated in terms of there's no objection raised to that.
Yes, and that's where, again, RMF also makes the argument that the probate court should have not denied its interest interest based on the precepts of equity. It did lose the loss of those funds during that period of time, and the appellee, as appellee acknowledged, that was through no fault of RMF's own. The proceedings just dragged out, and RMF didn't have the use of those funds during that period of time. And the law.
Is RMF sitting on its hands during that time, and does that come into our equitable consideration in terms of taking no action to recover that interest?
I would not say that RMF was sitting on its hands.
Sure you wouldn't.
Yes, Your Honor. But I believe under Tennessee law and the cases that are cited, the purpose of the interest is to compensate the party for the loss of the use of funds to which RMF was legally entitled. RMF was legally entitled these funds in March of 2017 and then did not have access.
No, those funds had not accrued in March of 17, had they?
Well, Your Honor,
You're wanting the interest from then to now.
Yeah.
That hadn't accrued in March of 17.
Yes, Your Honor. Not that those had not accrued in March of 2017, that the interest accrued after that fact. RMF was legally entitled. What I mean is RMF was legally entitled to funds.
Whether they asked for them or not.
Well, Your Honor, the contract is how RMF asked for them. The contractual obligation that Mr. Waller and the probate court agreed that RMF did nothing wrong.
So the probate court was just supposed to look at it and say, oh, it's been 4 years. Have some more interest, RMF.
No, Your Honor. The probate court was supposed to interpret the intention of the contracting parties, and if those.
Did you ask him to do it?
Yes, Your Honor.
You asked him for the interest?
In 2020, they were asked for the interest.
In 2020. Okay. Thank you.
Thank you.
Thank you both. We appreciate it. And would you please call the next case?
Mansour Shawnelius Burgess versus Bradford Hills HOA et al.